Hi, today I'm going to talk about the cases that have recently been recounted by the Trump administration and what does it mean for people that are being placed back in removal proceedings or immigration court, and what can they do to deal with this situation. Okay, all right. So before we go forward and for me to explain like what each individual should do, we have to talk about certain terminology as to in order to understand the full concept of what's going on. Okay, so what is administrative closure means? Okay, so administrative closure means when you had a case in immigration court proceedings, and whether by an agreement of the judge or both DHS or the respondent, the case was put to sleep. So if your case is administratively closed, that means the case still exists in immigration court, but it's sleeping, okay? And so who can reopen this case and put it back in calendar? It can be done by either the respondent themselves or the client. It can be done by an immigration judge or by DHS or government immigration in this case. So DHS basically stands for Department of Homeland Security, that represents the government. So, and it's usually filed by a motion to recalendar. So what's been happening lately is that after a decision that came out on June 2025 on the matter of BNK, the BIA said that if a case, if an individual who's been placed in immigration court proceedings and their case has been administratively closed, if the case has not been fully done, the government has the right to reopen this case. So this pretty much is being used as a weapon by the government to reopen the cases or individuals' cases that were previously placed in immigration court proceedings and their case were put to sleep, to be reopened so that the individual is placed back in deportation proceedings. Because towards the end of a case, whether a client is going to get his case approved or denied, and if there's a denial in his immigration court proceedings, then they receive a deportation order. So a lot of the cases that were placed in administrative court proceedings or were put to sleep under Obama or Biden's administration are now being reopened. Okay, now what should you do? And why is the government doing this? So obviously the Trump administration is way more aggressive and they want to deport as many people as they can. So by placing and recalendaring these type of cases, they're putting people back in immigration court proceedings so they can finish their case and be deported. Okay, so what should you do? I'll give you like an example from our own clients. So the best way to deal with this situation is to make sure that once the motion to recalendar is received, you respond to the motion. And in your motion, you should respond to both DHS and the immigration judge so that you can convince the immigration judge as to why your case should be placed back in administrative closure. So as to why your case should be put to sleep, okay? So whether you have some sort of a relief pending with USCIS or whether reopening your case would affect the relief you're seeking with USCIS, those are all good reasons, okay? Most of these motions are pretty much blanket and they don't necessarily have a lot of substance to them. They usually include the date where the case was put to sleep and why they're placing back, why the government wants this case back to be reopened or recalendared. So if you have a good reason, you should definitely state those reasons. Another reason to definitely convince the judge to put your case back to sleep is that if there is a new relief that you're seeking, like for example, if 5-10 years ago your case was administratively closed because you, for example, had an asylum, but now you're married to a U.S. citizen, that's a very good reason to state why your case should be administratively closed or put to sleep, because reopening your case would substantially affect the outcome of your case with USCIS. So that's a really, really good reason. Whether you have a good relief or not, if your case was administratively closed, then there was a good reason for you to accept that decision. So I highly recommend clients, or whether they're represented by attorney or not, they should definitely reply to this motion, respond to the motion, so they have something in the record that they did respond to the motion and the reasons that they stated that the motion should be granted. Okay. If you have like an alternative relief that can be pursued in immigration court proceedings, then maybe you should not respond to that motion. So for example, if when your case was administratively closed and you didn't have like a qualifying relative, or you didn't have like a 42B cancellation of removal relief, then if your case is placed back in removal proceedings and you're before an immigration judge and you can seek that relief, then maybe you should not. But be very careful. These motions, you only have like 15 days to respond to these motions. They're called reply motions, and make sure everything is done diligently, and you should state the reason as to why your case should be administratively closed, meaning that you have to oppose the motion that the government has filed. For more information, please visit our website and listen to our podcast. Have a nice day.